This is Steffi AI, focusing on newest developments in AI and the legal space. Please subscribe to my channel. ChatGPT has become the theme of the day with people having significant interest in the technology. However, this is also when it can go wrong if lawyers and individuals just utilize it without checking the facts. A lawyer representing a man who sued an airline relied on artificial intelligence to help prepare a court filing, and I can tell you that it did not go well. The lawsuit began like so many others. A man named Roberto Matta sued the airline Avianca, saying he was insured, when a metal-serving card struck his knee during a flight to Kennedy International Airport in New York. When Avianca asked a Manhattan federal judge to toss out the case, Mr. Matta's lawyer vehemently objected, submitting a 10-page brief that cited more than a half a dozen relevant court decisions. There was Martinez versus Delta Airlines, Tihiman versus Korean Airlines, and of course, Varghese versus China Southern Airlines, with its learned discussion of federal law and the tolling effect of the automatic stay on the statute of limitation. There was just one hitch. No one, not the airline's lawyer, not even the judge himself, could find the decisions or the quotations cited and summarized in the brief. That was because ChatGPT had invented everything. The lawyer who created the brief, Stephen A. Swartz of the firm Levidoff and Overman, threw himself on the mercy of the court on first day, saying in an affidavit that he had used the artificial intelligence program to do his legal research, a source that has revealed by itself to be rather unreliable. Mr. Swartz, who has practiced law in New York for 3 decades, told the judge Kevin P. Castle that he had no intent to deceive the court or the airline. Mr. Schwartz said he had never used ChatGPT and therefore was unaware of the possibility that its content could be false. He told Judge Castle even asked the program to verify that the cases were real. It had said yes. Mr. Schwartz said he greatly regrets relying on ChatGPT and will never do so in the future without absolute verification of its authenticity. Judge Castle said in an order that he had been presented with an unprecedented circumstance, a legal submission replete with bogus judicial decisions, with bogus quotes, and bogus internal citations. He ordered a hearing for June 8th to discuss potential sanctions. As artificial intelligence sweeps the online world, it has conjured dystopian visions of computers replacing not only human interaction, but also human labor. The fear has been especially intense for knowledge workers, many of whom worry that their daily activities may not be as verified as the world thinks, but for which the world pays billable hours. Stephen Gillis, a legal ethics professor at New York University School of Law, said the issue was particularly acute among lawyers who have been debating the value and the dangers of AI software like ChatGPT, as well as the need to verify whatever information it provides. Discussion now among the bar is how to avoid exactly what this case describes, as Mr. Gillis says, and one cannot just take the output and cut and paste it into one's court filings. The real-life case of Roberto Matta versus Avianca Inc. shows that white-collar professions may have at least a little time left before the robots take over. It began when Mr. Matta was a passenger on Avianca Flight 670 from El Salvador to New York on August 27, 2019, when an airline employee bonked him with his serving card, according to the lawsuit. After Mr. Matta sued the airline filed the papers asking the case to be dismissed because the statute of limitations had expired. In a brief filed in March, Matter's lawyer said the lawsuit should continue, bolstering the argument with references and quotes from the many court decisions that have since been debunked. Soon, Avianca's lawyer wrote to Judge Castell saying they were unable to find the cases that were cited in the brief. When it came to Varghese versus China Southern Airlines, they said it had not been able to locate this case by capture or citation, nor any case bearing any resemblance to it. They pointed to a lengthy quote from the purported Varghese decision contained in the brief. The undersigned has not been able to locate this quotation, nor anything like it in any case. Indeed, the lawyers added the quotation which came from Varghese itself, says something like Sihaman versus Korean Airlines, an opinion purportedly handed down by the U.S. Court of Appeals for the 11th Circuit in 2008. They said they couldn't find it either. Judge Castell ordered Mr. Matta's attorney to provide copies of the opinions referred to in their brief. The lawyers submitted a compendium of 8. In most cases, they listed the court and judges who issued them, the docket numbers, and dates. The copy of the supposed Verghese decision, for example, is 6 pages long and says it was written by a member of a three-judge panel of the 11th Circuit. But Avianca's lawyers told the judge they couldn't find that opinion, or the others, on court dockets or legal databases. Barbanino, a lawyer for Avianca, said this firm, Condon Fawcett, specialized in aviation law, and that its lawyer could tell the cases in the brief were not real. He added that he had an inkling a chatbot might have been involved. Mr. Schwartz did not respond to a message seeking the compound, nor did Peter Loduca, another lawyer at the firm. And it said that in an affidavit this week that it did not conduct any research in the question, and specifically also that there was no doubt of the sincerity of the work or the authenticity of the opinions that were provided. ChatGPT generates realistic responses by making guesses of which fragments of the text should follow other sequences based on a statistical model that has ingested billions of examples of text pulled from all over the internet. In Mr. Mata's case, the program appears to have discerned the labyrinthine framework of a written legal argument, but has populated with names and facts from a bullet-base of existing cases. Judge Castler, in his order calling for a hearing, suggested that he had made his own inquiry. He wrote that the clerk of the 11th Circuit had confirmed that the docket number printed on the purported Verghese opinion was connected to an entirely different case. Calling the opinion bogus, Judge Castell noted that it contained internal citation and quotes that, in turn, were non-existent. He said that 5 of the other decisions submitted by Mr. Mata's lawyer also appeared to be fake. On Thursday, Mr. Mata's lawyer offered affidavits containing the version of what had happened. Specifically, Mr. Schwartz wrote that he had originally filed Mr. Mata's lawsuit in state court, but after the airline had it transferred to Manhattan's federal court, where Mr. Schwartz is not admitted to practice, so hence one of his colleagues became the attorney of record. Specifically, Mr. Schwartz said he continued to do legal research in which the other lawyer had no role. And he had consulted ChatGPT to supplement his own work, and that in consultation with it, found and cited a half a dozen non-existent cases. And specifically, ChatGPT had provided reassurances. Specifically, asked whether Verghese is a real case, and the chatbot replied. Then the question was also, what is the source? And ChatGPT, however, then issued that it will apologize for the confusion earlier, and specifically that the cases that were provided are real and can be found in reputable legal databases. But the problem is that it couldn't be. Hence, it's really essential to check what the AI solutions provide, and the blatant reliance on the data may lead to such pitfalls. This is Dev AI, focusing on news developments in AI and the legal space. Please subscribe to my channel and put any questions or feedback in the comment section. Goodbye.